Good morning. Your name?
Heather Jurash.
You have 3 charges here. You have a vicious dog, no dog roaming at large, and then no dog license, and you have the right to a lawyer on this. One of these is a misdemeanor, the vicious act. So would you like a lawyer to represent you on this?
No, Your Honor.
All right, I'm going to formally arraign you, and then I'll let you go talk to the prosecutor. It is alleged that on June 28th of 25 at 9 p.m., that you were the owner of a dog that committed a vicious act on Pine Drive near Oakcrest in Brownstown. That is a misdemeanor punishable by up to $500 in fines, 90 days jail, costs or all those. That's count 1. The other 2 are dog roaming at large. That's a civil infraction, and no dog license. That is a civil infraction. Do you understand that?
Yes, Your Honor.
Did you sign an advice of rights and read and understand the rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
All right. Do you still wish to waive your right to a lawyer?
Yes.
And enter a not guilty plea.
Not guilty.
I'm going to send you to the prosecutor. I'm going to give you, can you tell me what kind of a dog this is?
She is a Border Collie and Rhodesian Ridgeback. She's 55 pounds, medium.
Okay. I'm going to give you a personal bond, $500. Here are your bond conditions. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No contact with the victim of the dog bite. You cannot write, phone, see, text, email, or communicate with that individual or have anybody else do any of those things for you or on your behalf. No contact with prosecution, witnesses. Dog to remain, listen very carefully to this, in a fenced-in yard, your home, or on a leash and equipped with a muzzle, okay? And equipped with a muzzle and accompanied by you or another suitable adult. Do you understand that?
Yes, Your Honor.
I mean, somebody over 18 that can control the dog, okay? I'm going to send you to the prosecutor. You can speak with her. And then either way, you're going to come back in here and speak with me, okay?
Yes.
Any questions? Okay, we'll see you in a few minutes. Timothy Sean Walsh, 25B148654A and B. Could I have Crystal Wren seated at the table, my right, your left? Crystal Wren over here at the table, my right, your left. Sir, your name?
Jim Walsh.
You're charged with driving on a suspended. We adjourned this until today. Did you talk to the prosecutor yet?
Today, no.
Yeah, you're supposed to do that. Do you want a lawyer?
No, sir.
Okay, you go in and you're going to speak with the prosecutor, all right? The township attorney. And then either way after that, you're coming back in front of me, okay?
Yes, sir.
All right, so you can go right out in the hallway. Thanks. People against Wren, Crystal Denisha Wren, 25B148897A, B, and C. Your name?
Crystal Wren.
You're charged with driving on a suspended, expired plate and no proof of insurance, and you have the right to a lawyer. Would you like a lawyer?
No.
I'll go ahead and arraign you and let you speak to the prosecutor then. It's alleged that you did operate a motor vehicle on Telegraph near Primrose in Brownstown on July the 6th of 25 with a suspended license. That is a misdemeanor punishable by up to $500 in fines, 93 days jail, costs or all of those in 2 points. Do you understand that?
Yes.
You're also charged with expired plate and no proof of insurance. Those are 0-point civil infractions. Do you understand that?
Yes, sir.
Yes.
Did you sign, read, and understand the advice of rights form here?
Yes.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
All right. You still wish to waive your right to a lawyer?
Yes.
I'm entering a not guilty plea. $500 personal bond. You don't have to post any money. But here are your bond conditions. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. Do you understand all that?
Yes, sir.
Any questions?
I did have insurance.
You go, no, that's, you talk to the prosecutor about it. Okay? Good luck. Either way, you're coming back in front of me. Come in. Can you come on in here, please?
I can, Judge.
Thanks. People against Robert Thomas Boyd, 25BA 2557. Your name?
Robert Thomas Boyd.
All right. Mr. Boyd, you have the right to an attorney. I'll be happy to give you one at public expense if you would like one. Would you like a lawyer?
No, thank you.
Ms. Foley Carter, your name, please?
Caitlin Fuller, Crime from Brownstown Township. I do have the ordinance enforcement officer. You have to grab them.
Please. I need an order. Probation order. Good morning, your name?
Rockers on behalf of Brownstown Township.
All right. Did you go out and look?
Yeah, there's no change.
Boyd. Mr. Boyd. You're gonna force me to do something that I don't wanna do. You're not gonna make me lock you up, are you?
I hope not.
Well, come on, you cannot have a dump sitting there in a township. It's a dump.
I've been working on it,
You have not been working on it. We were just out there.
and I've worked at it.
Well, what did you do since I went out and looked at the property back on July the 16th? Tell me what you've done.
Okay.
Come on, be specific now. I've got the ordinance officer sitting here.
Well, cut more brush down,
Where?
on the side yard.
What are you? Side yard. Where are the vehicles? They still there?
Yes,
The
sir.
boat,
They don't-
the trailer,
they don't
the
have
garage.
report over at my mechanic right now. I've called him twice and tried to get it over there to him, but he don't have room for it right now. I'll call him again today when I get out of here.
Mr. Boyd. They've warned you before. You've known about this case since at least the middle of April. This is the end of July. I don't know what I gotta do.
I'm working on it.
You're not working on it. It'll take you 42 years to get this place in the shape that it needs to be. At the pace that you're operating.
I'll work days.
Listen, I don't care if you have to hire contractors. The place is a dump.
I've tried to get help. I've tried to hire help.
Mr. Boyd,
Nobody wants to work. Willing to pay them $10 an hour a day.
$10 an hour. No wonder they're not willing to work.
Well, I make minimum wage. I work for it.
You're not gonna find anybody to come over there and deal with that mess for $10 an hour.
Well, they have to work with me, but it's,
Where do you work?
I work for, Motor City Solutions. I'm a test driver for Ford products.
This is just, this one request in your, did you send this to Mr. Boyd?
I did, Your Honor.
You got winter boat storage is only permitted on residential waterfront surfaces pursuant to your code 13.09.
Right, that's just to ensure that the boat doesn't remain there over the winter.
It's a dangerous structure to begin with.
Yes, sir, they've done a number on it.
Who's they? Who parked the vehicles there? Who parked the boat there? Who let the garage go to the point that it's dilapidated and needs to be taken down? Come on.
They tore it up.
I don't know what you're saying. You told me this when I was out there. I don't want to hear it at this point.
I mean, you saw the windows were knocked out of it. You saw the door was tore off it. I didn't do that. The door was tore off my tool trailer. I'm missing.
I have a feeling once I order this, you're not going to do anything.
I work on it every day I can.
Come on.
Really?
No, you don't. No, I don't believe you. You're not being truthful.
I am being truthful. It's rained a lot of days.
You told me that too.
Yes, sir. It's rained a lot this week. It's gonna rain today.
Is it? Okay, Sonny Elliott.
Pardon?
It rained Sunday, right? Or Monday? Did it rain Sunday?
Rain Monday.
I know. Did it rain Sunday? No. Did it rain Saturday? No.
Yeah, it did.
Did it rain Saturday? I wasn't here. Some,
It's rained a lot.
Mr. Boyd,
Saturday, we had, all them big thunderstorms come through.
all right. Listen, I've heard enough. I don't want to hear any more excuses.
Can't help the rain.
Mr. Boyd, I don't want to hear it.
Give me more time and Rob can keep an eye on me. I'll work on whatever he wants me to work on first.
Anything else? Anything else?
No, sir.
Anything else?
No, Your Honor, the people will just rely on us and it's not random.
Do you have any objection to any of these items that they're requesting in their sentencing memorandum?
Pardon?
They sent you this sentencing memorandum. Did you
Oh,
read it?
yeah. I saw that.
Did you read it?
Yeah, I got that on Monday.
Okay. Do you have any objection to following all these rules?
Yeah, as best I understand them, yes.
Listen to my question. Do you have an objection to complying with all these items that they're asking me to order?
No.
I don't know how in the world. I'm going to talk about a mechanism for timeliness. And I got to tell you, I don't want to hear any more about the rain. Okay? that is just six months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance of any unit of government. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. I'm not going to copy all of this. I'm going to put it in an order. Amy, you can tell probation. Here are the conditions. All vehicles parked on the property must be located on a concrete or asphalt driveway surface. They have to be licensed.
I have a stone driveway.
Stop, I want to hear it. I'm going to tell you what, I'm telling you, it has to be on a concrete or asphalt surface. It has to be licensed, and the vehicles have to be operable. Any vehicles that are not operable have to be stored inside an enclosed building or removed from the property. I don't think you have an enclosed building that's going to accommodate all the vehicles you have there. So you got to get them off the property if they're inoperable. Any recreational vehicles such as your boat, anything else must be operable, licensed, and registered to you or the occupant of the property. You have to have any recreational vehicle stored on a hard or pervious concrete, asphalt, permeable, grass pavers, or gravel surface. They must be used for their intended purpose and not as storage. So you can't just have a boat in there and throw a bunch of junk in there. All non-permitted accessory structures have to be removed. You do not live on a residential waterfront surface, so winter boat storage will not be permitted on that property. The garage must be torn down and removed, and any excavation thereunder filled to grade level. Did I sufficiently cover that one? I think I did.
I think so, Your Honor.
Junk, trash, rubbish, tarps, anything that creates rodent harborage or refuse of any kind needs to be removed. Okay?
Okay,
Junk includes parts of machinery or motor vehicles, unused stoves or other appliances stored in the open, remnants of wood, metal, or any other material or other cast-off material of any kind. Weeds, grass, and undergrowth must be cut and maintained so as not to be higher than 8 inches pursuant to ordinance. You are to allow township officials on your property for a compliance inspection, at least weekly or more. Now, I want to know about a timetable here. This is only 6 months and I want this done quickly. Sir, you seem like a nice man, but you cannot have that kind of junkyard in the middle of the township. You can't. Well, I know you say you understand, but you're not moving. You gotta move.
I feel like I have to move. I don't have a whole lot of time after work, I get,
I don't know what to tell you. That property did not reach that level of sloppiness, junkness, whatever you want to call it, overnight. I would have to say it's taken years. You gotta move. Now,
sir.
Tabitha, type up everything on there, and you're gonna attach it to this order. Now, let's set timetables. If you guys have any ideas, can you help me with this? What do you want out of there first?
Probably garage.
Yeah, the road and harborage, that type of stuff is probably the biggest hindrance or, the biggest complaint from the township is the road and harborage, which includes trailers and the garage. I mean, there's trailers that we didn't even see that, behind in the brush.
Why don't you get your sons to help you?
Pardon?
Why don't you get your sons to help you? You said you had 2 sons last time, did you not?
He's working 7 days a week, 12 hours a day. My other son works up the other side of 15 Mile Road.
How are you gonna get the garage torn down?
That's my main goal,
Well, I need it done now. How long is it gonna take you?
I don't know, I gotta see about getting a junk trailer and,
Well, I know, but I want a timetable. I'm giving it until September 1st to have the garage removed.
how about Christmas?
No. Christmas,
Might have to end up doing it myself.
sir. I don't think you're understanding. Christmas. This is the problem, you're procrastinating. September 15th, I want it down. We're setting a review hearing date, Amy. I need a review hearing date, garage to be removed by September 15th. I don't care how you do it, who you hire, who helps you, who doesn't help you. I want it done by then. I'm not gonna worry about the excavation levels at that point, but by September 15th, give me a review hearing date, please, right on my first docket day after September 15th with Brownstown.
September 24th at 8:30.
Did she say December?
September.
December.
And then when you come in at the time, now I'm not saying you shouldn't be working on other things either. But I want that garage down by September 15th. So you're gonna put that in the order. All vehicles. How are you gonna do this? How are you gonna do this? You're gonna have to get rid of those vehicles.
I'll find a place for 'em.
Order, you include this, order pertaining to vehicles must be complied with by October 1st. Do you understand?
Yes, sir.
We'll send you this order. You're gonna pay fines of 200, costs of 100, 75 victims' rights fee, $50 justice assessment. I'm not looking at making you go broke here. 545 is your total, including its probation fees. We're gonna give them a review hearing date in 6 months also. So prosecutorial review hearing date will take place should be mid-January.
January 14th.
January 14th, 26 at 8:30. I cannot repeat enough. I think you're a very nice man. So I want to print out a review hearing for September 24 at 8:30. Review date, January 14 to 26 at 8:30. And John, when you go over probation, I want them to schedule an appointment for him to come and see them because I have to type up this order.
Okay.
Okay? Anything else you want me to do or asking me to do?
No, Your Honor, I think this is fine for Mr. Boyd.
I'm just going to give you until January 1st to pay all your fines. Okay? Actually, I'm going to make it December 20th of 25. You have to pay all your fines by then. You go down and get your printed notices. You're going to go over to probation. They'll tell you when you have to come back. I have to have an order typed up. I need to file that.
Your Honor, with my job, I have to deliver cars to Ohio and
Yeah, you could, I told you at the time of the bond, but thank you for bringing that up. You can leave the state for employment purposes, okay?
thank you.
You can leave state for employment purposes. Now, I want to make sure that you're not going to go out of here, leave this building, and forget about everything I just said.
No, sir. I have that paper at home.
Okay? Let's get started. Good luck. If you violate your status 771, I'm taking this under 771.1. Case will be dismissed if you're compliant. If you're not, conviction will enter and you're subject to a 90-day jail term. Do you understand that?
Yes,
You're
sir.
not going to make me do that, are you?
I hope not.
Well, I don't want there to be hopes. You got to get moving, sir. I've heard enough about rain. Good luck.
Thank you.
Joshua Jordan Lazarick,
Ready.
255-415-022. Good morning, Mr. Bulahanis.
Good morning, Your Honor. May it please the court, Greg Bulahanis, P36431, on behalf of Mr. Lazare.
Mr. Lazarick, your name, sir?
Joshua Jordan, Lazarus, Your Honor.
Lazarick, okay. All right, so for purposes of arraignment, does he stand mute and waive formal reading?
Yes, Your Honor.
So I will enter a not guilty plea, and now there's going to be a plea to operating while impaired. I actually have a B file, another file, I should say, 25002, ticket number I-415.
He's completely responsible for the PBT refusal as well.
Right. Okay, so is that what you want to do, sir?
Yes, Your Honor.
You hesitated. You sure?
Yes.
If you plead guilty to operating while impaired and responsible to PBT refusal, I'm going to dismiss the operating while intoxicated on motion of the prosecutor. The possible penalties on this charge are up to 300 fines, 93 days jail, 360 hours community service. Court costs are all those. 4 points will be added to your traffic record. Your license will be suspended or revoked in accordance with your record. And your vehicle could be or might have to be immobilized depending upon your record. You understand that?
Yes.
And did you sign, read, and understand the advice of rights?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights and there will not be a trial. Do you understand that?
Yes, Your Honor.
Okay. To the charge operating while visibly impaired, how do you plead?
I'm sorry, can you say that again?
Sure. How do you plead to the charge of operating while visibly impaired?
Guilty.
On May 30 of 25 at 8:15 PM, were you operating a motor vehicle on Meridian near Grosio Parkway in Grosio?
Yes.
Did you drink alcohol prior to that? And if so, what did you drink and how much?
Yes, mixed drinks and roughly around 5 or 6,
What kind of mixed drinks?
vodka and lemonade.
And was your ability to operate that vehicle impaired because of the consumption of the alcohol?
Yes.
In what way? Why were you pulled over by the police?
He was unable to maintain his lane.
Is that right? You were crossing the center line, is that true? Or driving onto the over the fog line?
Yes, Your Honor.
And you think you did that at least in part because of your alcohol consumption?
Yes.
Was this a breathalyzer or a blood test?
Breathalyzer, Your Honor.
And what were the results?
0.21 and 0.22, I think.
And you so stipulate that was an accurate plea?
Yes, Your Honor.
Accurate reading for purposes of the plea?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
All right, I'm gonna accept your plea. I find it to be an accurate plea made voluntarily and understandingly. The plea is accepted. I'm going to dismiss the OWI and to the charge PBT refusal, responsible or not responsible.
Responsible.
Okay, I'll accept that plea. We're gonna defer the sentence on that. I'm gonna have it at the same time as I have the operating while impaired. I'm gonna give you a $1,000 personal bond. You don't have to post any money, but you cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. I'm gonna order that you, it's a week, and that's gonna be in person. We're gonna give you a form. Every time you go, you have to have the form signed. Every time you come to court, you have to bring the form with you to evidence that you've been attending. So you wanna make sure you get that signed. Don't lose it. Don't let your dog eat it. Anything else that I've heard over the last 30 years. Okay? Do you understand everything?
Yes, Your Honor.
Where does he work, counsel?
DTE, and he is attending counseling, Your Honor.
Bernie Ball.
No,
Okay.
he's suffering from depression. He has a counselor that has been seeing for the last couple of months. Is that correct, sir?
I've been seeing a therapist for the last couple of years. There's,
Okay.
Roughly about a 6 month time span where he moved, and then I got back in touch with him. I've been seeing him every other week. I also see some help through the VA.
Good. So you were in the service?
He's honorably discharged after 9.5 years.
In what branch?
Marine Corps, Your Honor.
Congratulations. Thank you for your service.
And,
I mean that. My father was in the Marine Corps. He's a major, and I have the highest admiration for anybody in the military. So let's get you back on track. You can do this. We'll give you a sentence date. And I will have you, you're going to be screened and assessed today. You'll come back for sentencing, okay? Mr. Gulahanis, make sure you, if you don't have an AA verification sheet, grab one from my court officer when he returns here.
Yeah,
Give me
we
an
can,
AA sheet. Give me a sentence date, Lisa, or Amy, rather.
August 27th at 8:30.
If you, counsel?
1 second.
Sure.
I can't do it at 8:30.
Okay, we'll do another day. I don't need this.
We can do the 13th. I'm sorry, Judge.
I don't really need it to be on a Trenton day, or Rosio day rather. There's no restitution or anything. There's no accident, so we can set whatever date. I can do a Monday if you want, whatever you want, Amy. Yeah, I work for you.
The-
Are you good the 13th?
Or the 14th.
Okay, hold on 1 second. 1 second. August 13th. The 13th, I have 2 cases. You said or the 14th?
Yeah, we can do the 14th.
August 14th is good.
Whoever has that phone's gotta shut it off and get out of the courtroom.
Folks, you gotta take your phones out of here, please. We got signs all over the building.
Do you want that in person or Zoom?
I don't care, as long as you're in the same location.
Yeah, I'm always with my client.
Yeah, I don't care. If you want to do it in your office, I'm fine. He's with
At 8:30 a.m.
August 14th, 8:30.
Okay.
Okay?
Yeah, if we can do Zoom, that'd be great.
That's fine.
Thank you so much.
No
Aaron.
problem.
And
Have a good day.
You want him to see the probation officer right now?
I do. You're going to be screened and assessed. You're going to fill out a questionnaire and be interviewed, okay?
Thank you so much, Ron.
Thank you. Good luck.
You and your staff have a great day.
You too. Thanks.
Appreciate it.
Mexicat. Tyler James Mexicat, 25B148704A and B. Your name?
Tyler James Mexicat.
So you're charged with possession of a concealed weapon and possession or use of a controlled substance. You have the right to a lawyer. Would you like one?
Yes, Your Honor.
I'll set you up with a lawyer. And then you also have another file here, 23R513044. That is a Rockwood case. Is Rockwood here today, Amy?
No, Rockwood is not here. I think that was a warrant cancellation.
That to the lawyer. Where you been? You're supposed to be here in 2023. What happened?
I honestly don't even remember that.
You know what the title of my book's gonna be? Don't tell the judge I forgot. Okay? And that's gonna be the title of my book. Go talk to a lawyer, then come on back in here, okay? See you back here in a few, Mr. Mexicott. Barnier. Brianna Ray Barnier, 25B148694, A and B. Your name? Is that your phone? Is that your phone or your mom's? Fraudulent schemes and contributing to delinquency of a minor. You have the right to a lawyer. Do you want one? I'll set you up with one, okay? Go out in the hallway, get your, you meet with the lawyer will meet with the prosecutor, and we'll go from there. Tabitha. Don't forget to type that as soon as we get off, okay? Thanks. Melnowski. Joel Dean Melnowski, file number 25B148750. How you doing, Mr. Melnowski?
Good morning, sir.
Your name?
Joel Hoffsky.
You're charged with a super drunk violation, which is punishable by up to 6 months in jail. You have the right to a lawyer. Do you want one?
Please.
Okay. We'll set you up with an attorney. All right. Good luck. Who is our lawyers today? Gio and Crawford. Here's one for an attorney. Thanks.
Yep.
Do you have anything else down there? Morning, Mr. Teal.
Good morning,
Morning,
Judge.
Mr.
How are
Gilbert.
you?
Good, thanks. John Earl Davis, 25W392000, A and B.
Good morning, Judge Bianca, on behalf of Mr. Davis, state your full name for the court.
John T. Davis.
All right, so we're gonna adjourn this one last time, right?
Yes, Judge.
Okay, I'll go ahead and adjourn it out a couple weeks, Lisa. I mean, Lisa's not here today, Amy.
Judge, could you do 30 days, only because he has to go.
How many does he have to clear?
Quite a few.
Where do you work?
Disability.
How's he gonna come up with all the
He's
money?
indicated to me that he has the money to pay everything, so he's just gonna.
I'll give you 4 weeks. Don't ask again, though, okay? All right, give me, give me 4 weeks out, Amy.
September 3rd at 9 o'clock.
I don't have one at the end of August.
Well, this is a Woodhaven case, it looks like, so
Okay, good enough. September 3rd at 9 a.m. Set for trial if not resolved. Listen, if it's not resolved, then I'm gonna have to set it for trial. Do you understand that? So I'm giving you about 5 weeks, so you go take care of that, all right?
Okay.
All right, any questions?
No question.
Go right down the hall, we'll give you a notice. Good luck, September 3rd, 9 o'clock. Randy Allen Tedora,
Thank
25B, thank you, 148572.
Good morning, Judge Bianca, on behalf of Mr. Fedora, state your name for the court.
Randy Tedora.
All right, I need a order. Mr. Tedora pled guilty to open house party. The agreement was that would be taken under section 771.1, with length of time to be in the court's discretion. Today's the date scheduled for sentencing. Anything you would like to say?
Yes, Your Honor, Mr. Tador has been employed at Ford Motor Company for 29 years, and he has indicated to me that he is able to pay the fines and costs today.
Okay, anything else?
No, Your Honor.
Mr. Tadora, why were you doing this, Mr. Tadora?
It was a bad day on May 10th.
I'm sorry?
It was just a bad day on May 10th.
I know, but you had 50 kids that were drinking at your house. What if one of them gets
It only
drunk?
happened 10 minutes. I mean, it was not a party that I had 35 people show up in 10 minutes. And not one of them knew who I was.
Some teenagers had a notification set that I don't know,
You don't authorize your kids to have parties, drinking parties at your house with minors, do
No,
you?
that's not how it happened. I
Well,
mean, I had 30 kids on my sidewalk and not one of them knew who I was or anybody in
Did
the
you
house.
tell them, you better get out of my house, you're drinking, it's,
Yes, they looked at me and didn't know who I was and was the rudest people I've ever met. And they were exactly the same way to the police officer. He lined them up on all my sidewalk and not one of them was from Woodhaven and not one of them knew who any of us was in the house.
well, if they're rude people,
They were coming through the backyard, they were jumping fences. There were 3 cars with 35 people in them. It all happened. I mean, if it was a party for 2 hours, I would have had the cops called a long time ago. I mean, it was just shock and awe, seriously.
your kids invited some people over.
All 30 of those people didn't even know who my kids were. Didn't know anybody from the party.
You mean they all just decided we're gonna go up and drink at this house with nobody inviting them? They were in there illegally? Come on.
They came in through the side, they came in through the
I
back.
know, but
guess
somebody invited them, whether your kids invited 4 kids or 2 kids or 20 kids or 30 kids, somebody invited those kids over there. They didn't
According
just,
to the police report showed that none of those kids knew who we were or had the address. They showed up to a friend's location, but none of them, they were lined up on my sidewalk. Now, one person from Woodhaven, and
they were hiding in the back room, according to the police report.
yeah,
You had bottles of vodka in there. They were playing beer pong. Somebody let the kids in. They didn't break into the house and start playing beer pong and bring bottles of vodka with them. Now, listen, don't make this worse than it is.
I know,
Somebody needed to call the police if they were breaking into their house, right?
they did. The cops came 5 minutes after.
Did
they
you
showed
call the
up.
police?
The girl that was in my
Did
house
you call the police?
My next door neighbor called the police.
Ah,
Why, I was trying to.
did you, did your kids call the police?
They were in shock. They didn't know any of these people. They didn't know any of these people. I mean, I can't believe that you're saying that you don't know what 17 and 18-year-old kids are doing nowadays. They don't care.
Mr.
They
Todora,
don't care.
Mr. Todora.
Yeah, all right,
I could tell you stories that you wouldn't even comprehend.
I get it, I'm learning now.
Don't tell me that I don't know what's going on out there, but your story does not make sense, that 30 to 50 people just started congregating in your house without permission, without your knowledge, without your kids' knowledge, and they're playing ping pong, beer pong, and having bottles of vodka. You're making it kind of worse for yourself because you're not accepting any
I
responsibility.
accepted all the responsibility. I'm just telling you what happened.
You keep interrupting me, so that isn't good. 6 months probation under 771.1. You cannot leave the state without the consent of the court. You cannot violate any law. You change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. I'm going to order that you serve 2 days of community service. You have to have that complete by September the 10th, okay? 16 hours community service by September the 10th. You're going to pay $100 in fines, $100 in costs, $75 victims' rights fee, $50 justice assessment, $120 in probation fees, $40 in attorney fees. Everything included here amounts to $485. If you violate, your probation could be revoked. You could be incarcerated for 90 days. If you're compliant, at the end of 6 months, you come back. I'll be more than happy to dismiss this case on motion of the prosecutor. We're going to give you a review hearing date. You're going to go down the hall, pay your fines. Then you're going to go over to probation where they will instruct you. Do you understand everything?
Yes.
All right. Give me a date in mid-January.
January 14th.
At 8:30 in the morning, sir. January 14th at 8:30 in the morning. You come back. If you're compliant, the case will be dismissed. Do you understand all that?
Yes.
All right. Any questions at all, Ms. Patillo?
No, Your Honor.
Do you have any questions, sir? All right, probation will instruct you. Go down, pay your fines, pick up your notice, don't lose it, and then go meet with probation. Best of luck. Thank you.
Thank you, Judge.
I'm gonna real quick take this one. Don't go anywhere though. Stevens Disposal and Recycle, 25B148990A and B. Your appearance?
Yes, good morning, Your Honor. Jeff Osmond on behalf of Stevens Disposal.
I don't see where she took any action. Can you call her in, please? You're going to plead responsible to overweight. You're authorized to enter into that plea on behalf of the company with agreed upon fines and costs of $2,000, true?
Yes, Your Honor.
What did she do with the other one? She doesn't have any,
The other one, the defective equipment was, I believe, was going to be dismissed, and we did the overweight for 2,000, and I was going to ask for 30 days to pay.
okay, let me just get her in here real quick. Your name?
Caitlin Foley Carter.
You didn't take any action. You didn't write down. Are you dismissing the defective equipment?
I am.
Would you write that on the stip form, please? To the charge of overweight, Mr. Osmond, responsible or not responsible on behalf of the company?
Responsible.
Plea is accepted, $2,000, paid by August the 30. I'm dismissing on motion to prosecutor the defective equipment. Okay?
Thank you, Your Honor. Have a good day.
You too. Thanks a lot. Okay. Mackenzie Goff. Mackenzie Lynn Goff, 25B148638. This is A and C.
Good morning, Judge Deanna Patillo on behalf of Ms. Dawn Station for the court.
Oh, wait a minute. You gotta go. Okay, you gotta go a lot louder than that.
Mackenzie Ball.
Can I have the victims up here, please? Come on up. How old are you?
16.
Go off the YouTube.
Stand right over there.
You stop right there. Please. No, yeah, you blocked it. Push it over. Thank you. Oh, so this is your car right here?
Yes, sir.
Okay. And that's where everybody is around here, correct?
Yes, sir.
Okay. Go ahead, start. You're still coming towards your car. That's when you said Chris came around near your car. And they're still arguing, correct?
Yes, sir.
Okay, you moved up a little bit,
Yes, sir.
so. And now Chris is by you backing up.
Trying to get in my car because he was trying to leave.
Okay, so he was trying to leave even before the shots were fired.
Mm-hmm.
Okay, and when did you leave? Was that you walking back? Was that you?
The person that ran.
Can you go back and just break order? Someday I'll put you can for me. Okay. So that's Chris. All right, go ahead. Good one. And he tried to get in the back, I guess, even the back. Keep going. Was that after you?
Go backward.
Yeah, I wanna see what you ran. Okay. So, so you left there even before the shooting or about that, but he tried to get in the back of your car to get away even before the shooting started.
Wait, is that a question
Yeah.
or are you testifying?
No, that's a question, Judge.
Okay, it didn't sound like a formal question.
Yeah, you tried to get, you went to get away or you ran away even before the shooting started.
No, I ran when I hit the gunshots.
Did you see him duck down? Did you
Him.
see him duck down by the?
Who was him?
Him, pronoun. She
Oh,
even asked his name.
did you see Chris duck down by your car?
I ain't seen him.
Well, you saw it on the video, right? That he ducked
Yeah, I
down?
seen on the video, there's no dick.
Okay. You testified that during this confrontation was 3 against 1, correct?
Yes, sir.
And that you saw Miss Guidry, the mother, spit at Chris.
Yes, sir.
Did you see Mr. Williams pull a gun out?
No, sir.
Did you see him point it and try to fire it and it jammed?
No, sir.
You weren't looking, you were running away.
Yes, sir.
You said that you really didn't know them, or did you just know the daughter?
I only know the daughter, she used to stay at my grandma's house with us.
Don't even know the daughter.
I do know
You do know her.
her, yeah.
You kind of knew her kind of well, didn't you?
Yeah, we grew up together.
Okay. Because you stated that when you ran, I guess you ran around the apartment?
I ran straight down him, you can see in the video.
Okay, but you ran right into the apartment, their apartment.
After the shooting had stopped, yeah, I went and checked on Joseph.
Okay, so how did you get there? I mean, did you run around the apartment or
No, I politely walked back once everything was done, once Chris was gone,
you politely walked back?
you know.
And when you say you walked back, you come back through here and just walk through the front door? Or did you go around?
I walked through the front door.
And by that time, Chris was gone
Yes, sir.
and Joseph Williams was back in the apartment waiting for EMS.
Yes, sir.
There's been testimony after this all happened. Did you leave the facility or the apartment complex? After this all happened?
I went to my house.
You went to your house. Did you make any stops?
Nope.
Nothing at all? Didn't stop at Walgreens?
I had to go to Walgreens because my cousin went to jail from him.
Oh, so you stopped somewhere.
That was after I got the call. I went home first.
So you went home first, okay. So you went home first and then,
I got a call that my cousin was about to go to jail.
okay, and was somebody released into your custody?
No,
Macron or Maron? Who's your cousin? What's your cousin's name?
my cousin was Marcus,
Marcus who, Young?
younger.
Okay, he's the one that had traffic tickets, right?
Yes, sir.
And wasn't there another or a young boy with him?
Yeah.
Right, did he get a ride home from you?
He got a ride home from my aunt.
Did you have your aunt with you?
My whole family was right there.
Okay. How did you get notified that he got stopped who notified you?
They had something to do with this case?
No, how did you get notified to go to Walgreens?
They my cousin.
Yeah, but who notified you to say that they were stopped at Walgreens?
My cousin Marcus called. As
Okay,
they was getting pulled over.
so as he was getting pulled over, he called you,
He wasn't the driver yet.
okay? And he said, come here because I think I'm going to jail?
That's his exact word.
Seeing that you walked in front of the apartment to go into the Guidry's apartment, did you pick up a firearm?
No, sir.
Did you realize that the firearm was in the bushes in the front?
No, sir.
But you would agree with me that even though you may not remember, you stated that Chris was waving you down as you were leaving the apartment,
Yes,
correct?
sir.
That he was trying to get into your backseat of your car before the shooting started,
Yes, sir.
and that you saw 3 people against 1, and you saw Mrs. Guidry, the mom, spit at him before this all went down,
Yes, sir.
and him backing up, trying to get out of that situation.
Yes, sir.
Subject to recall, Your Honor, I pass the witness.
Do you remember telling officers that Joseph Williams didn't even take out his handgun until Chris had shot 4 to 5 times?
Yeah, I told him he's coming in town after Chris had done already shot.
I have no further questions, Your Honor.
They say said, yeah. Mr. Arlington, when you gave the statement on October 3rd of 2023, did you ever mention in your statement that anybody pulled out any gun? Either Mr. Williams or Chris? You never said he never pulled out any gun, did you?
I don't remember.
You said that there were gunshots between Chris and Joseph, but you never said that Joseph never pulled out a gun, did you?
No, sir.
Yeah, not in your written report. And you did this that day, Officer wrote it out, you gave a statement. According to the state's questioning, you were cooperative, I guess, right?
Yes,
You gave a statement and then initialed it twice, correct?
Yes, sir.
Okay, nothing further, Judge.
Just to clarify, you gave that written statement to an officer, right?
On video.
Okay, so do you remember giving the written statement to a different officer?
I mean,
Okay.
I don't remember.
But you gave a video interview to Detective Cater, is that right?
Yes, ma'am.
And he asked you a bunch of questions, is that correct?
Yes,
Right?
ma'am.
And during that interview, you said who had shot first and all of those things. It was a much longer statement.
Yes, ma'am.
Okay. No further questions, Your Honor.
Nothing further, Judge.
Your excuse, ma'am. Thank you. Next,
At this time, Your Honor, state rests.
what says defense?
I need a couple of minutes, Judge.
How much is a couple of minutes,
I
really?
need to talk to my client,
15, 20?
and not even that, 10 minutes is fine.
Okay, break, ladies and gentlemen, 10, 15 minutes. Thank you very much. Everyone else remain seated while the jury exits.
Morning to you, Mr. Lavelle. Samsung, Samsung SMA156U, good morning to you. What is your name, please?
Sarissa Valdez.
Good morning to you, Ms. Valdez.
Good morning, Judge.
City of Detroit versus Sarissa Marie Valdez. Case numbers SP166-18911, SP166-18933, SP167-7505, counts 1 and counts 2. Here, state your name for the record, please.
Sarissa Valdez.
Ms. Valdez, today is the date and time set for a review. You were ordered to do and allowed to do a combination of ordered to do community service and in lieu of fines and costs, allowed to do some community service to clear it up. I see that you completed those community service hours, and thank you for that. Let's see what actions we said we were going to take. So for SP166-8911, that's going to be closed out. SP166-18933, that is going to be dismissed. SP167-75051 is going to be closed out. Just check it in. I'm bouncing around. I'll be back. SP167-75052 is going to be dismissed. Ma'am, if you don't have any further questions, we wish you the best of luck and have a very good rest of your day, all right?
Thank you so much, Judge.
You're welcome.
Thank you.
All right, All right, we're just gonna check a few more people in and we're gonna get going. On the telephone at 541-221-1950. Good morning to you. What is your name, please? Telephone 541-221-1950.
La persona con teléfono 541-22.
Michael Ojukwu.
Michael Ojukwu, you were signed in already.
Yes.
I guess we took too long for you, huh?
Huh?
We took too long letting you in, huh?
Well, I'll be in. Yes, sir.
All right. Sit tight, Mr. Ojukwu. Good morning to you.
Good morning.
Good morning, sir.
Samsung, good morning to you. What is your name, please? Samsung, the ceiling fan is going.
I'm sorry, this is Timothy Gar.
This is who?
Timothy Gar.
All right, good morning to you, Mr. Gar.
Good morning.
iPhone, just let you in the room. Good morning to you. Start your camera, unmute yourself, state your name, please. Sir, are you driving, sir? Unmute yourself. All right, I'm gonna put you out of the room. You're driving in court. Zoom back in when you're at a safe location.
All right, we recall State of Texas versus Christopher Keller.
Please unmute yourself.
23 CR
Start your camera and state
1768.
your
All
name,
parties
please.
are present. Bring the jury in, please. Thank you.
We have something to put on record before.
Hold on. Go ahead.
iPhone, start your camera, state your name, and unmute yourself, please.
Raise your right hand. Do you solemnly swear or affirm any statements you make
Can you
will be
hear
the
me?
truth, the whole truth, and nothing but the truth, so help you
I
God?
can hear you.
Yes.
Good morning to
Lower
you,
your
ma'am.
hand.
What's your
Thank you.
name, please?
For the record, could you state your name, sir?
Christopher Keller.
And Christopher,
Are you on the
then,
iPhone?
in this trial, still has rested their case in chief. It is
Good morning to you, ma'am. What's your
our
name,
turn
please?
to put on any evidence, that we may have at this trial, you understand?
I didn't hear that.
One of the things that now you have an opportunity to testify or not to testify, you understand?
Yes, sir.
Yes. Okay. Now, that's
Say
a
that again,
decision that you'd
please.
have to make, and we've talked about it at length, correct?
Yes, sir.
And you have an absolute right to take that stand and testify and tell the
I'm not-
jury
I'm
your
not
side
going
of the story.
Good response. I'm gonna
Yes,
turn your
sir.
You
camera off.
also have an absolute right to remain silent. That is not take the stand.
Good morning. What
Understand
brings
that?
you today? What city is
If you
today?
decide that, the jury will get an instruction from the court that because of your failure or your decision not to testify, they cannot take that into consideration in their deliberation of finding you guilty or not.
Thanks for joining us. Good morning on the iPhone, ma'am. What is your name?
Have you made a decision of whether or not you'd like to testify or not?
Ma'am, on the iPhone.
I don't like to testify. I wouldn't like to testify.
You do not want to testify?
La señora que está en tu iPhone, ¿cuál es
In
su
making
nombre?
that decision, was it
I
based
don't
on
think she needs an
conversations
interpreter,
between yourself
Okay, Your Honor,
and
thank you.
myself,
I don't
you
think so.
and me?
That she's having trouble.
This is
The device is not.
Yeah, but we talked about it,
We
right?
talked about it.
All right, I'm gonna start letting them in.
And no one
and,
has
we'll
forced
go-
you to do that, correct?
No, sir.
You've done it freely and voluntarily,
Yes, sir.
no promises, nothing, and you've made this decision based on everything that's occurred.
Yes, sir.
Okay, nothing further, Jeff.
Bring the jury in. Thank you.
Good morning.
Good morning.
I'm welcome. Also, sir. Joseph Kahusky.
Please remain silent. The 36th District Court for the State of Michigan is now in session with the Honorable Judge Sean Perkins presiding. While in court is no sleeping, no eating, no drinking, no driving, no smoking. Gentlemen, please remove hats. Ladies, please be well dressed. Good morning, Your Honor.
Buenos días a todos. Esa es la Corte de Distrito número 36 y estamos en la sala del honorable juez Sean P. Perkins para el propósito de la Corte Comunitaria. Mientras estemos en sesión, le pedimos a todos, por favor, que no estén ni comiendo, ni fumando, ni tomando y que no estén tampoco manejando. Le pedimos a todos que no tengan la cabeza cubierta con gorra, cachucha, lo que sea, a menos que sea por razones religiosas. Y le hablo ahora a las señoras y a las señoritas, por favor estén vestidas adecuadamente, como que si estuvieran en la corte en persona. Gracias a todos y bienvenidos.
Okay.
Clear channel now show that the jury is seated in the courtroom. I think when we broke, the state rested. What says defense?
This time, Your Honor, the defense rests.
There, okay,
Yes.
ladies and gentlemen, both
What is your
parties have
name,
now
please?
rested. The court doesn't know what's going to happen until you hear it and I hear it. So what this means is I'm going to have to finalize a jury charge that the court has been working on. It's going to take me a little bit of time. I'm going to ask you to relax, stretch your legs for about 30 minutes. And then report back outside. And if we can get that charge finalized,
Everybody's gonna have to
then
mute
I can
their
read the charge,
devices,
the lawyers can
please.
make final arguments, and then y'all can
Turn your
begin
televisions off.
your
Le pedimos a todos que apaguen las
deliberations on
televisiones
this
y que
case.
también
Okay,
tengan su
thank you for bearing with
dispositivo
us. And
silenciado hasta que llamemos
take a
a su
break and
caso.
relax. And also there's a place downstairs that's open, the Honeybee Hand. I think it has coffee and things like that.
Pues todavía estamos
Thank you
conectados,
for your
nomás no te
patience.
pueden ver.
Everyone else remains seated while the
Es
jury
que está
exits.
I need my blood pressure checked.
On the iPhone, sir, turn your camera on, sir.
Say it again?
All right, there's no driving in court, all right?
Oh, yeah, sorry about that, Your Honor.
What is your name? Good morning to you.
Good morning, sir. Christopher Graham.
All right, good morning. I'm gonna do the best I can to get you out as fast and efficiently as possible. And I'm gonna try to get you out in the order that you came in.
Voy a hacer todo lo posible para llamar los casos en la manera más rápida y eficiente posible. También sépanse que voy a llamar los casos en la orden en que han llegado.
I expect that you're gonna be decently dressed and up and attentive when we call your name.
Espero que todos estén listos para cuando llamemos el caso, que estén sentados derechitos esperando que llamemos a su nombre y vestidos adecuadamente.
And especially you're not driving while in court.
Y también muy importante que no estén manejando mientras estamos aquí en la corte en sesión.
All right, it may take a while. We have a number of people in court today, so bear with us.
Puede que nos tardemos hoy. Tenemos varias personas aquí en la corte hoy. Así que le pido a todos que se vistan de paciencia.
All right, Mr. Ogletree, I'm gonna get you going on, Mr. Randolph Williams.
Yes. I'm here.
Are you up, sir?
Yeah, I'm in the hospital.
All right, now let me ask, let's do this. Mr. Williams, are you gonna able to participate today, or do you need us to get you another date?
No, I won't get this over with. I'm guilty.
Okay, that's not what I asked you, Mr. Williams, but, now, this is Ms. Monteo here?
A ver, ¿está la señorita Buentello presente?
Mr. Phillips, you want to introduce the community court today, see who wants to participate and who does not?
Señor Phillips, le pido a usted que usted nos explique lo que es la corte comunitaria para que sepamos cuáles personas aquí quieren participar y cuáles no quieren participar.
I don't think it's gonna work. Your volume is not very good.
I'm sorry.
Okay, everyone, today
Ms.
is.
Quintero is in the waiting, Your Honor.
Pero usted tiene que estar ahí.
Okay. Good morning, Ms. Buenteo.
Yes.
Buenos días, señora.
Good morning, Your Honor.
Can you introduce community court and see who would like to participate by a show of hands in the Zoom room, or who would not like to participate by a show of hands in the Zoom?
Y puede usted, por favor, señorita Buentello, dejarnos saber lo que es la corte comunitaria para que si yo le pueda preguntar a todos presentes quién quiere y quién no quiere participar.
I can absolutely do that, Your Honor.
Absolutamente que eso puedo hacer, su señoría.
Welcome to community court, everyone.
Bienvenidos a todos a la corte comunitaria.
Community court is an arrangement with the 36th District Court.
La corte comunitaria es una corte donde hemos hecho nosotros arreglos con la corte de distrito número 36.
Where you can opt in to do community service.
Y pueden escoger participar en servicio comunitario.
Receive additional social support.
Y puede que reciban otras ayudas sociales.
Y potentially have your fines or cases dismissed.
Y es posible que sus multas queden desestimados y al final de su servicio comunitario que sus casos queden desestimados también.
Welcome to community court, everyone.
Así que le doy la bienvenida a todos a la corte comunitaria.
Now, it is a community service component in this, and if you do not want to complete community service or do community service as part of that component, if you don't have the last name beginning in G, L, or O, I'm going to send you to your alphabet judge.
Bueno, sépanse todos que en esta corte y parte de esta corte es el servicio comunitario para resolver los asuntos. Si no quieren participar en la corte comunitaria y no tienen apellidos que comienzan con G, L o O, por favor, déjenos saber, levantar la mano por el chat para que sepamos que no quieren ser parte de esta corte para resolver sus asuntos.
Is there anyone in here that does not want to do community service as part of their sentence?
¿Hay alguien aquí que no quiera hacer servicio comunitario como parte de la sentencia? Déjenos saber, levante la mano.
Raise your hand in the Zoom room if you do not want to do community service.
Si no quieren hacer servicio comunitario para resolver su asunto, levanten la mano por el Zoom. Levanten la mano para que se vea.
Kim, you could just stay here. I'm gonna take care of you anyway. All right, let's get going. Mr. Alex Paradise Gonzalez, are you dealing with the housing insecurity?
Así que vamos a comenzar con Alex Pérez González. Y señor González, ¿está usted ahora lidiando con la dificultad de encontrar un lugar donde vivir?
No, no.
No, no.
Who was dealing with the housing insecurity?
¿Y quién es la persona que no tenía hogar?
That was me, Your Honor.
And who's that? I'm sorry.
Nicolas Gomez.
Nicholas Thomas. All right, good morning. I'm gonna put you in the breakout room with Mr. Patel. He's gonna come speak to you, okay?
Thank you.
Is there something else that's dealing with housing insecurity?
¿Hay alguien más que está luchando con el poder encontrar dónde vivir?
Anyone else dealing with housing insecurity?
¿Alguien más que no tenga la seguridad de su propio hogar?
This is the city of Detroit, Mr. Ogletree versus Randolph Williams Jr. Case number SB 1740592, counts 1 and counts 2, SB 1740609. Appearance for the record, please.
Aaron Ogletree, about Mr. Randolph Williams.
Could you please unmute yourself and state your name for the record, please?
Oh.
Unmute yourself, sir.
Randolph Williams.
All right, good morning to you. Today is the date and time set for Mr. Ogletree.
Wait for Marina, stand mute.
You are not guilty to any client. You have to give your client a $0 bond. Get your client an updated offer. Keep in mind, if you don't like the offer, Mr. Williams, you have an absolute right to a trial. I'm gonna put you in a breakout room with Mr. Ogletree, and you have a conversation with him. Let us know what you want to do when you come out, okay?
Okay.
Five is gonna be your room, Mr. Ogletree.
Fine.
That's past the matter. All right, let's go back on the record with Mr. Alex Perez Gonzalez. Mr. Perez Gonzalez, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Vamos a
Your
ver
Honor, my client.
el caso del señor Alex Pérez González. Señor Pérez González, le di la oportunidad de hablar con su abogado en una sala privada de consulta. Dígame, abogado, ¿qué quiere hacer su cliente?
Your Honor, my client would avail himself of the people's current offer, which is to have him enter a plea to allowing as well as improper plates.
Su señoría, mi cliente quiere aprovecharse de la oferta actual de resolución que le ha propuesto la fiscalía. Se va a declarar culpable a haberle permitido a una persona sin licencia conducir y se va a declarar culpable a que llevaba las placas incorrectas.
Okay, Mr. Alex Gonzalez, this is not a revolving door. You're not going to continue to have to come back and be able to get these offers and keep offending. You understand that, sir?
Ok, señor Alex González, comprenda que esto no es una situación donde usted puede entrar y salir, volver a entrar y salir y conseguir buenas ofertas de parte de la fiscalía.
Okay.
Ok.
All right, can you raise your right hand, please?
Bien, ¿puede usted levantar la mano derecha, por favor?
Do you swear or affirm to tell the truth, whole truth, nothing but the truth?
¿Jura usted declarar toda la verdad y nada más que la verdad?
Sí.
Yes.
Put your hand down.
¿Ya puede bajar la mano?
All right, let's get this understanding. I'm gonna send you, send it to community service but the community service is not done this time, then the deal is gonna be off the table. And it is, you're not, and the misdemeanors are gonna stay on your record. You understand me?
Bueno, quiero decirle esto para que entendamos lo que estamos hablando, señor. Le voy a permitir a que usted vuelva a hacer servicio comunitario, pero si usted no llega a cumplir sus horas de servicio comunitario, entonces la oferta de resolución que tiene usted aquí se desaparece. Y los delitos menores de cuales usted ha sido acusado permanecen en su récord, como antecedentes penales. ¿Comprende usted, señor?
Sí.
Yes.
You understand the maximum possible penalty for these offenses are 93 days in jail and/or $500 in fines?
Y comprende usted que la penalidad máxima que usted pudiera recibir son 93 días en la cárcel o un máximo de $500 en multa?
Sí.
Yes.
You understand that you have an absolute right to a trial?
Y comprende usted que usted tiene un derecho absoluto de ir a juicio?
Sí.
Yes.
Mr. Berry went over your other advice or rights in the breakout room, did he not?
Y el señor Berry revisó con usted sus otros derechos constitucionales cuando estaba usted en la sala de consulta, ¿no es cierto?
Sí.
Yes.
You understood those rights?
¿Y usted comprendió esos derechos?
Sí.
Yes.
Any questions about those rights?
¿Alguna pregunta que usted tenga acerca de esos derechos?
No.
No.
No, by taking this deal, you're going to give those rights up?
¿Sabe usted que al aceptar esta oferta de resolución, usted renuncia a esos derechos?
Sí.
Yes.
Has anybody offered you anything other than what's been stated in the record?
¿Y alguien le ha ofrecido usted algo diferente de lo que ya hemos hablado en el acta?
No.
No.
Let me draw your attention back to June 27, 2025, about 5 a.m. in the city of Detroit, in the area of Central and Berner. Did you have an occasion on that day to come in contact with the Detroit Police Department?
Your Honor, you broke up 5
Yeah.
a.m.
No, 1:05 a.m. in the city of Detroit, in the area of Central and Berner Highway. Did you have an occasion on that day to come in contact with the Detroit Police Department?
Entonces, señor, permíteme llamarle la atención a la fecha del 27 de junio del 2025, aproximadamente a la 1:05 de la madrugada, en el área de las calles de Central y Berner en la ciudad de Detroit. ¿Tuvo usted ocasión de encontrarse con un policía del Departamento de Policía de la ciudad de Detroit?
Sí.
Yes.
Were you operating a motor vehicle?
¿Iba usted manejando un vehículo motorizado?
Sí.
Yes.
Did the officer ask you to produce a valid driver's license and insurance?
¿Y el policía le pidió a usted que le enseñara una licencia vigente de conducir y seguro de vehículo?
Sí.
Yes.
Did not do so, could you?
Y usted eso no pudo hacer, ¿no es cierto?
Mi licencia no la tengo y esta estaba vencida, la aseguranza de la camioneta.
Yes, I don't have license and my insurance had expired.
Very well, and find your client guilty of the amended count of allowing for license never acquired and amended count of improper plate for not having the valid insurance.
Muy bien, así que acepto entonces la declaración de culpable que presenta su cliente a haberle permitido a una persona sin licencia a conducir en vez del cargo original que no tenía licencia y cargo de que tenía las placas incorrectas en vez del cargo original de no tener seguro de vehículo.
Okay.
Okay.
Is your phone number still 313-778-2464?
Y su número de teléfono es aún el 313-778-2464?
Sí.
Yes.
You still have the number to the Southwest Detroit Community Justice Center?
Y usted aún tiene el número del teléfono del Centro de Justicia de la Comunidad del Suroeste de Detroit?
Se me hace que se me borró, es que se me borraron muchos contactos. ¿Me lo puede dar?
I think it's erased. I lost a lot of my numbers in the contact section of my phone. Could you give it to me again?
313-879-2155.
313-879-2155. 313-879-2155.
Okay.
Okay.
On the 2 counts you just pled to, is gonna be 14 hours of community service for each count. And then you have the 12 hours of community service that you did not complete the last time you were here, for a total of 40 hours of community service.
Así que le voy a pedir que usted haga 14 horas de servicio comunitario para cada uno de los cargos, más que termine de hacer sus 12 horas, las cuales usted no había cumplido para el otro caso. Así que llegamos a un monto de 40 horas.
All right, if there's nothing further, sir, call Mr. Phillips or Mr. Mateo this afternoon to complete the hours. We don't have any further questions. I wish you the best of luck. Have a very good rest of your day.
Así que no, si usted no tiene algo adicional, le voy a pedir que llame ese número de teléfono esta misma tarde y que pida hablar con el señor Phillips o con la señorita Buentello para que hagan los arreglos. ¿Dónde, cómo y cuándo va usted sus horas de servicio comunitario? Si no tiene algo que agregar, le deseo a usted muy buen día y buena suerte.
Okay, muchas gracias.
Okay, thank you very much.
This is the city of Detroit versus Robert Carl Gardner. Case number is SP 17-04109. Counsel 2 and 3. Appearance for the record, please. Mr. Berry.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Mr. Gardner.
Robert Gardner.
All right, good morning to you, sir. Mr. Berry, Mr. Gardner has taken time set for a pretrial. On a no insurance civil, he still owes $170, which would probably prevent him from getting a license. I don't know if he already has a license or not, but it'll probably prevent him from getting a license if he doesn't have one. He's paid it down. He's paid at least $50 to afford it down to $170. To get Mr. Gardner updated offer, keep in mind, Mr. Gardner, if you don't like the offer, you have an absolute right to a trial, okay?
All right.
Join the room, please, or pass the matter.
Yep.
All right, let's go back on the record with Miss Natalie Lewis. Miss Natalie Monique Lewis, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, my client is going to enter a plea to 1 count allowing and admit responsibility to blocking traffic.
Is that what you want to do, Ms. Lewis? Where's Miss Natalie Lewis? Did we lose her?
Possibly. She indicated no, she's still here.
Ms. Lewis, is she unmuted?
Yes,
I'm here.
Ms. Lewis, can you raise you want to take the deal, ma'am?
Yes, sir.
Can you raise your right hand, please? Do you swear or affirm to tell the truth, whole truth, nothing but the truth?
Yes, I do.
And you can put your hand down. You as well, Ms. Lewis, you can't keep getting these deals like this. And it's supposed to be a one-time deal, but I'm gonna give you the opportunity to do some more community service and keep this off your record this time, all right? But this is the last time.
Okay.
You understand?
Yes, I do. Thank you.
All right. Yeah, you understand that you have the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Yes.
You understand that you have an absolute right to a trial?
Yes, I do.
Ms. Harris went over your other advice and rights. Ms. Harris went over your other advice and rights in the breakout room, did she not?
Yes.
You understood those rights?
Yes, I did.
Did you have questions about those rights?
No, I don't.
You know, by taking the deal, you're gonna give those rights up?
Yes, sir.
Has anybody offered you anything other than what's been stated in the record?
No.
Let me draw your attention back to May 29th, 2025 at around 2:54 PM in the city of Detroit in the area of Plymouth and Rosemont. Did you have an occasion on that day to come in contact with the Detroit Police Department?
Yes.
Were you speeding on that day, ma'am?
Yes, sir.
And did the officer ask you to produce a valid driver's license?
Yes, but I couldn't
And why is that?
because they suspended.
Find your client guilty, excuse me, guilty of the amended count of allowing order to do 12 hours of community service for that. And find your client responsible for the amended count of blocking traffic for the speeding. In lieu of fines and costs, allow her to do 12 hours of community service for that. I'll dismiss the allowing upon completion.
So you know when the next court date will be, so I can know how long I got to complete the hours.
It's gonna be, I forgot to tell Mr. whatchamacallit, September 9th. Mr. Phillips, let the last defendant know September 9th is gonna be the review date. And is this 313-808-3981 still a good number to reach you?
Yes, sir.
You still have, you went through, our community service department. I'm gonna refer the matter to community service. You should have a community service. And I'm gonna have you back on 18 hours. We'll complete everything. I'm gonna have you back on September the 3rd, 2025.
September the 3rd or the 9th, sir?
September the 3rd.
Okay.
At 8:25. Best of luck to you, ma'am. Have a very good rest of your day.
All right. Oh, thank you.
Good. This is the city of Detroit versus
Sorry about that.
Isaias Granada, case number SP 1744681, counts 1, 2, and 3. SP 1744761. Appearance for the record, please.
Erica Harris, on behalf of the defendant, Granda, please state your name for the record.
Es el caso de la ciudad de Detroit contra el señor Isaías Granda.
Señora,
Por favor, diga su nombre para que conste en el acta.
Isaías Payares Granda.
Isaías Payares Granda.
All right, good morning to you, sir. Today is the date and time set for a pre-trial experience. Mr. Granda, updated offer. Keep in mind, Mr. Granda, if you don't like that offer, you have an absolute right to a trial. I'm gonna put you in a breakout room with Ms. Harris. Let us know what you want to do when you come out.
Señor Isaías Granda, Payares Granda, hoy es el día y la hora establecido para su consulta previa al juicio. Lo voy a mandar a una sala de consulta privada con su abogada para que le consiga una buena oferta de resolución. Y si no le gusta, sepa y entienda que tiene todo el derecho de ir a juicio. Por favor, únase a la invitación cuando la vea allí enfrente de usted, por favor. Is he there, Your Honor?
You see. Yes.
Thank you.
All right. You're welcome. Let's go back on the record with Mr. Williams. Mr. Williams, I've given you an opportunity to speak to counsel. Counsel, what does your client want to do? That's Mr. Ogletree. Hey. Mr. Ogletree, are you ready on Mr. Williams?
Yes, Your Honor.
We're back on the record. We're going to need to speak to counsel. Counsel, what your client want to do?
There's been an updated offer, and the offer is if he pleads to allow a light driver to drive, then the other charge be dismissed.
Yes, ma'am. Thank you. How are you today?
A little tired, but I'm okay.
Stop talking, please. Lydell? All right, you want to take the deal, Mr. Williams?
Yes.
Can you raise your right hand, please? Do you swear or affirm to tell the truth, whole truth, nothing but the truth?
I do.
You can put your hands down. Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Yes.
Understand that you have an absolute right, and you have an absolute right to a trial?
Yes.
Mr. Ogletree went over your other advice or rights in the breakout room, did he not?
He did.
You understood those rights?
I do.
You have any questions about those rights?
No, sir.
You know by taking the deal, you're gonna give those rights up?
Yes.
Has anybody offered you anything other than what's been stated in the record?
No.
We draw your attention back to June 12, 2025, around 12:53 p.m. in the city of Detroit, in the area of Fort Lawndale. Did you have an occasion on that day that you be operating a motor vehicle and get stopped by the police on that around that date and that time?
Yes, I did.
Did the officer ask you to produce a valid driver's license?
He did.
You couldn't do so, could you?
Correct.
And why is that?
Suspended.
Very well. Find your client guilty of the amended count of allowing with stipulation of probable cause. I'll dismiss the other matters.
We stipulate.
All right. What about, do you want to do community service when you get out of the hospital? They got some stuff in the accident calls or something like that, or do you want a money judgment?
I just got my lawn removed. Judgment. Yeah, but I'll take the money judgment.
You say what? Who said what?
He said he wants the money judgment.
Since you're in the hospital, I'll still will insist upon payment. When can you pay it?
Probably by the middle of the month. By 2 weeks.
I'll give you some time to recover. Come on back on September 4th. September 4th. Pay it at any that kiosk in the city of Detroit. I'm told you can upload that app to your phone, or you come on down to the courthouse and pay it in person. Those are the two best ways I can tell you to pay it, sir. I wish you a speedy recovery. If it's paid, we'll dismiss the case. If you don't have anything further, I wish you the best of luck. Okay.
Okay. Thanks a lot, Judge.
You're welcome.
Over to
you. Is Jesus Manuel Gonzalez Soto here?
Jesús Manuel González Soto está presente.
Correcto, sí, señora. Aquí ando.
Yes, ma'am, I'm right here.
All right, let me go ahead and call, get Mr. Ogletree started on Joseph. Is that? Joseph.
Sorry about that, Your Honor. I was trying to get on.
Right, good morning to you, sir. Give me the correct pronunciation of your last name.
Joseph Kahusky.
Kahusky, I'm sorry. City of Detroit versus Mr. Ogletree, case versus Joseph Kahusky, case number SP 173024141. Appearance for the record, please.
Aaron Ogletree, behalf of Mr. Joseph Kowalski. Can you state your name?
Mr. Kahusky, state your name for the record, please.
Joseph Donald Kahusky.
All right, today is the date and time set for a pre-trial. Give Mr. Kahusky an update offer, Mr. Ogletree. Keep in mind, if you don't like the offer, Mr. Kahusky, you have an absolute right to trial. I'm going to put you in a breakout room, Mr. Ogletree. Have a conversation with them. Let us know what you want to do when you come out, okay?
Okay, thank you very much.
Mr. Williams, you can hang up.
I'm trying.
I'll put you out.
Thank you.
All right. Mr. Patel, are you ready?
I'm not, Your Honor. I just asked Alexa to hop into the breakout with me in 7.
Very, very well. I'll put her in 7. All right. Let's go back on the record with Mr. Robert Gardner. Mr. Gardner, I've given you an opportunity to speak to counsel. Counsel, what your client want to do?
Your Honor, my client would avail himself of the people's current offer to enter a plea to allowing and the remaining matters to be dismissed.
Is that what you want to do, Mr. Gardner? Where's Mr. Gardner? You want to take the deal, sir?
Yes.
All right. You want to do some more community service to clear up all this stuff here?
Yes.
Raise your right hand, please. You swear or affirm, tell the truth, whole truth, nothing but the truth?
Yes.
Or you can put your hand down. Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Yes.
You understand that you have an absolute right to a trial?
Yes.
Mr. Barry went over your other advice or rights in the breakout room, did he not?
Yes. Yes, he did.
You understood those rights?
Yes.
You have any questions about those rights?
No.
You know, by taking the deal, you're going to give those rights up.
Yes.
Has anybody offered you anything other than what's been stated in the record?
No.
Let me draw your attention back to April the 16th, 2025, around 11:46 a.m. in the city of Detroit, in the area of Myers and Kendall. Did you have an occasion on that day to come in contact with the Detroit Police Department?
Yes.
Were you operating a motor vehicle?
Yes, I was.
Officer asked you to produce valid driver's license.
Yes.
You couldn't do so, could you, sir?
No, I couldn't.
Why is that?
They suspended.
I'm gonna find you guilty of the amended count of allowing, with stipulation probable cause to dismiss the other 2 matters.
So stipulated, Your Honor.
All right, I'm gonna order you to do 12 hours of community service on this matter. I'll allow you, in lieu of fines and costs, to do another 12 hours of community service for the civil infractions. I will take your first hour of community service, first 6 hours of community service, and you can zoom back in once you're done, or have Mr. Phillips let us know that you've completed those. And I'll take this no insurance civil and we'll call it good on that. That's what's affecting you, at least with the 36th District Court, from getting a license if you don't already have one. I need a good phone number from you, sir.
248-252-6769.
All right, I'll set the matter for review on September the 4th. Strike that, September the 3rd, 2025. You give Mr. Phillips a call to set the hours up this afternoon. Like I said, once you complete the first 6, you can zoom back in, and then the other matters, we'll give you an opportunity to complete those. Come back on September 4th. If you don't have any further questions, wish you the best of luck. Have a very good day.
Okay.
Presentation of evidence in this case. The court has submitted a proposed jury charge to the parties. Have the parties had an opportunity to review it? Any corrections or changes to it? State?
Not from the state, Your Honor.
Defense?
Not from defense, Judge.
All right. Bring the jury in, please. Thank you. Record shall also show now that the jury is seated in the courtroom. When we broke, I think the parties have rested their cases. We are now ready to go into the reading of the charge and final arguments. But do the parties have any additional evidence to present in this case, state of Texas?
Nothing from the state, Your Honor.
And defense?
No, Your Honor.
Ladies and gentlemen, the parties have rested, and at this time, I'm going to read to you the jury charge that has been agreed upon by all the parties and submitted by the court. And this will be read to you. And this is the charge of the court, which contains all the law applicable for your deliberations in this case. In continuing to discharge your responsibilities as jurors, you must continue to observe all the instructions that have previously been given to you. These are given to you because your conduct is subject to review, the same as that of the witnesses, parties, attorneys, and myself. Please listen carefully, as I know you will, as I read this charge to you. The original will be left with you to refer to as necessary during your deliberations. Members of the jury, the defendant stands charged by indictment with the offense of aggravated assault with a deadly weapon, alleged to have been committed in Jefferson County, Texas, on or about October 3rd, 2023. The defendant has entered a plea of not guilty to this indictment. Our law requires that I now submit the following charge to you in this case. This charge contains all of the law necessary to enable you to reach a verdict. If any evidence was presented to raise an issue, the law on that issue must be provided to you. Definitions. So that you can better understand some of the words and terms used in this charge, the law provides the following definitions. Assault. A person commits the offense of assault if he intentionally or knowingly or recklessly causes bodily injury to another. Aggravated assault with a deadly weapon. A person commits the offense of aggravated assault if he commits assault and uses or exhibits a deadly weapon during the commission of the assault. Intentionally. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. Knowingly. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. And recklessly. A person acts recklessly or is reckless with respect to a result of his conduct when he is aware of, but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the defendant's standpoint. Deadly weapon. Deadly weapon means one, a firearm, or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or two, anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Firearm. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using energy generated by an explosion or burning substance, or any device readily convertible to that use. Serious bodily injury. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Bodily injury means physical pain, illness, or any impairment of physical condition. Self-defense. It is a defense to this prosecution if the defendant's conduct was justified by law. Force. A person is justified in using force against another when and to the degree he reasonably believes the force is immediately necessary to protect himself against the other's use or attempted use of unlawful force. Deadly force. A person is justified in using deadly force against another if he would be justified in using force against the other, and in addition, one, a reasonable person is in his situation would not retreat, and two, when and to the degree he reasonably believes the deadly force is immediately necessary to protect himself against the other's actual or apparent use or attempted use of unlawful deadly force. The self-defense charge for this case, therefore, even if you believe from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, that the defendant, Christopher Keller, used deadly force as alleged in the indictment, but that on such occasion, the defendant reasonably believed this use of deadly force was immediately necessary to protect himself against the victim's actual or apparent use or attempted use of unlawful deadly force. And one, a reasonable person in the defendant's situation would not have retreated, and two, the defendant reasonably believed that the use and degree of deadly force he used was immediately necessary to protect himself against the victim's actual or apparent use or attempted use of unlawful deadly force, then you should find the defendant not guilty. However, if you believe from the evidence beyond a reasonable doubt that at the time and place in question, the defendant either one, did not reasonably believe that the victim was actually or apparently using or attempting to use deadly force against him, or two, that a reasonable person in the defendant's situation would have retreated, then you shall find against the defendant on this plea of justification by self-defense. Defendant's election not to testify. Our law provides that the defendant may testify in his own behalf if he elects to do so, and this is a right given to a defendant. And in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer to or allude to that fact throughout the deliberations or take it into consideration for any reason whatsoever. Stand by. Charge. Now, if you believe from the evidence beyond a reasonable doubt that in Jefferson County, Texas, on or about October 3rd, 2023, the defendant, Christopher Keller, did then and there intentionally, knowingly, or recklessly cause bodily injury to Joseph Williams by shooting Joseph Williams with a firearm, and the defendant did then and there use or exhibit a deadly weapon, to wit, or namely, a firearm, during the commission of said assault, then you shall find the defendant guilty of the offense of aggravated assault with a deadly weapon. Unless you so find, or if you have a reasonable doubt thereof, you shall find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or otherwise charged with an offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. You have a right to consider all of the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are in this case. And in evaluating this evidence, you must totally disregard what you believe is my opinion about any factual matter. You must not consider facts that have not been introduced into evidence or legal principles that are not contained in this charge. And it is improper for any juror to discuss or consider anything which they know or have learned outside of the testimony presented to you and the law contained in this charge. If a juror should discover that they do have any outside information, they must not mention this information to any other juror, nor consider it themselves in arriving at a verdict. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. And you must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. You cannot question the bailiff concerning the testimony or the law, and nor should you discuss the case in his presence. If any question about the law develops during your deliberation, it must be reduced to writing and signed by your foreperson and then given to the bailiff. That question will be answered by the court as soon as possible to the extent allowed by the law. And there have been exhibits admitted. Any physical exhibits admitted into evidence will be furnished to you by the bailiff upon your request. After the attorneys present their arguments to you, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during your evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict which is attached to the charge. In returning your verdict, it is your foremost responsibility to make certain that justice is done in this case in accordance with the law and the evidence presented. And ladies and gentlemen, we have two verdict forms here. One, we the jury find the defendant guilty of the offense of aggravated assault with a deadly weapon as charged in the indictment, a place for the foreperson to sign. And the other, we the jury find the defendant not guilty of the offense of aggravated assault with a deadly weapon as charged in the indictment, a place for the foreperson to sign. Obviously, only one verdict form can be signed. Under the rules, the state of Texas may open and close final arguments. What says the state?
We waive our right to open, but reserve our right to close.
Defense?
Counselors. First off, ladies and gentlemen, thank you very much for your time and listening to the evidence. In reference to trials, though you hurry up and wait and have to wait while we do things that are probably legally necessary, this has been a very fast trial. It's not much to this case, and we only had several witnesses testified, but we also have a video that you can go back and look at. if you didn't get a sense when we were sitting here Monday afternoon, basically what I was trying to tell you during voir dire was that we wanted you to do your job. Good, bad, indifferent, guilty or not guilty. And what I told you was that I was looking for 12 people that would be unbiased and fair, that would listen to all the evidence 150%. Go back there and make a decision. Let's put it on the table and you all decide. The other thing is, and we talked about a little bit, and I mentioned it, was that I feel, and I think a lot of people, some people don't, that when the state has the burden of proof to prove each and every element, along with each and every element, I categorize it as the totality of the circumstances. What is behind that? They've alleged that Chris has used deadly force. Well, the totality of the circumstances isn't as cut and dry as I hope that you might have seen now during the testimony. That there were other factors, other outside influences that affected what happened. And what makes this case kind of unique, though has not been the first time, if you do this long enough, that this has happened, that after the dust is settled, after everybody has gone their way and you realize it's been almost 2 years, no one wants to get involved anymore. No one wants to say anything. No one wants to do anything. Even to the point where someone's actually shot and says, I don't want to be here. It's over. It was a spat. We should never have done it. Okay? Doesn't make sense, but it is. The state has made a point to say, look what, and look how many shots that, and it appears that it came from Chris there in reference to the shooting. It also shows where, and through his own admission, Mr. Williams, the complainant, also shot back. Mr. Williams doesn't know who, when, where, or how anybody did it. The only thing he knows was he was running, heard shots, felt whatever it was, and then decided to start shooting wherever he was. Well, that may not have been the truth. What I saw, and of course what I see, and my argument and the state's argument is not evidence, it's just comments, and I point out what I think is the important parts that I think I'd ask you to focus on when you go and deliberate, just as the state is going to tell you what they think parts you have to. But what I want to take into consideration is once, if you piece it all together in reference to all the witnesses and the evidence and everything else, what you have is an argument. What you have is somebody that has been dating someone for 17 years and probably considered married, not married, common law, whatever it was. They loved each other, hated each other, depending on what day it was. But it is what it is. They really didn't talk any bad about Chris after somebody shooting a family member. I guess they still liked him and loved him. Don't know. But as you guess through the witnesses, one witness says it was 3 against 1. So there were 3 family members that you have to take into consideration, the Guidrys and Williams against Chris. And you saw that. You see that there. Of course, Mr. Williams doesn't want to say he was wearing white, but it doesn't take a rocket scientist. You have to use your reason and common sense. It's right here in the chart. So that's not a rocket scientist. So you know there's a fight and you know there's words. But as you look at that, and I pointed out was that during several times, who's backing up? Who's backing up and who's not going towards them in an aggressive manner? That gentleman right there. As you look, he first goes over to the car. Now we know why he's going over to the car, though she really didn't remember, but it was in her statement. He's waving to her to come over, to come pick him up. Why would you wave, hey, come over here? That's what she said at the time, back in October 3rd. All right, so he wants out of there. He knows what's going to happen. I want out. And as you can see, the people are standing on the passenger side of the car, and he walks over away to the driver's side.
There's a conversation there, and I would submit to you, get me out of here. Well, why do I say that? Because also in the video, what you see is him opening up the back door. Now, these people are street smart, okay? They've been around. They know. She doesn't want anything to do with it. Oh, no, you're not getting in my back car. Stay out. I know what's fixing to happen. But he tried to retreat. And that goes to the self-defense issue that I'm going to talk to you about in a minute. But he's trying to get out of there. And what did she say? You ain't getting in my car. No. He slammed, door closes. So what do you see then? He goes back to the front, and there's another confrontation between the guy in the white and him. Now the question is, and the state keeps harping on it, who shot first? Well, in reality, probably Chris did. Okay? But why? Mamas don't lie. Especially, I'm kind of surprised because it's her child that was shot. What did Miss Guidry say? Her son pulled the gun, pointed it, and it jammed. Now, how do we know that? Well, we didn't get it from Williams because he didn't do anything except run. That's all he was doing. He was running. He didn't even know what he was wearing that day. Okay? But when you look at that video, you see him hunch down in the front by the fender, and he hunches down. Why would anybody hunch down unless, oh, I'm fixing to get shot? And you remember what I did to Miss Guidry? And what was her reaction? Oh, whoa, wait a minute. He knew what was going to happen. He knew exactly what Williams did. And Williams would have shot first if it didn't jam. Mama said it jammed. Well, what do you do when the gun jams? You run. Run, Forrest, run. Forrest Gump. What did he do? Fell for his safety. He ducked down, got up, started shooting. Now, I want you to remember too, because I asked questions, that it wasn't that he was down the road and he started shooting. Okay? You need to take a look at the picture. Because what he did was, this car is right next to each other, 10, 15 feet according to the both sides of the detective. The window that was hit is over here. So he's shooting across the car, not down the road. So the shots were fired because the window was broken. Remember, the state brought it up. There's the broken window in the Guidry apartment. There's the car right next to him. Okay, and he ends up down here. So it wasn't like, oh, you run down there, let me do some target practice. It was right there over the hood of the car, and it shows because the window is broken and you see it right there. And then put insult to injury. What did we hear from Miss Garling? That she remembers Mama spitting at the defendant. Now, if that's the only thing we had, I would tell you he was not justified in using deadly force, because you can't do that. That's not going to kill you, spit. But when someone pulls out a gun and pulls the trigger, and the point that Mama knows that jammed, you know he pulled the trigger. You know it, because she didn't have to say that. You will get an instruction in reference to self-defense. And it goes through. It is a defense. Conduct is justified by law. Force is justified using against another to the degree he reasonably believes the force is immediately necessary. Click. I think that's almost immediately necessary, just because it misfired. Justified. In addition, a reasonable person in this situation would not retreat. Well, he did try to retreat, and it indicated that. So you don't have to consider that. A reasonable person would try to retreat, and that's what he did. He tried to get away, flag a car down to get a ride, go over and talk to the passenger, go back, still Williams is going after him, tried to get into the back seat before any shots at all were fired. And then his reaction of ducking down behind the fender, knowing I just got shot at, but it jammed. Not knowing what's going to happen the next second. And number two is, to the degree he reasonably believes that the deadly force is immediately necessary. I don't know how immediate and how necessary we can show it. Thank God it didn't go off, because it would have been point blank right at him. Couldn't have missed. Right at him, because you see it in the video how close they are. If that's not immediate and necessary, heaven help us all. I believe as you read this, it's the second page, which is the instruction on self-defense charge, that we have met the burden of the state in reference to the self-defense. We're not here to decide whether it's good law or bad law here. It is whatever the law is on October 3rd of 2023 that you must take into consideration. Good laws, bad laws are meant for the legislature, and that's to enact. But there's a reason why they put self-defense in there. And this is the perfect case for that. Do I agree that any argument, especially family, should be settled with guns? No. And you can tell it didn't start out that way, because they were arguing. They were, because they like to argue. I guess they love to argue and then make up. But mama was there and brother was there, and he was outnumbered. But it clearly shows he was trying to get out of there. He was trying to get away before a gun was pointed at him, and he had to take the action that he did. I ask you to go back. It is proof beyond a reasonable doubt. It is something that I told you, and it's just my comment, that when you walk out of here guilty or not guilty, that you feel good about what happened. It is not anything to be sad or disappointed if the state has not met their burden. And even if they did, if you agree that it was self-defense. You might not agree with their lifestyle, and you might not agree with how they try to settle arguments. And I don't think a gun and an argument and anything, especially in family situations, is prudent, wise, and it never leads to anything good. Thank God no one was killed. But in this case, ladies and gentlemen, it was self-defense. Because you see that right there. Clear as day. Clear as day. And in this case, as the last sentence in this jury instruction that you're going to get says, it is your duty to see that justice is done. That's what you're charged to do, and that's what you took an oath to do. And in this case, ladies and gentlemen, it is not guilty based on self-defense. Thank you all for your time.
State of Texas.
Thank you, Your Honor. I brought you guys plenty of people. I brought you officers to testify about the physical evidence, and then I brought you actual witnesses. Every single person that saw something there, I brought you. The good, the bad, and the ugly. All right. Here, let's talk about her for a minute. She's dated the defendant. Probably will still date the defendant. No matter the outcome of this. She doesn't want to testify against him, right? It took me asking her, I don't know how many times, for her to finally admit that she told the officers that Christopher Keller shot her brother. At no point in her testimony did she say her brother shot first. And she's protecting him, right? That entire time she was protecting him. And when we brought up her kid, she didn't want to talk about where they were because she knew that they were in danger when he was shooting and she didn't want to admit it. Joseph Williams, my victim, he testified. Again, extremely unwillingly. Unwilling to admit that he even knows Christopher Keller. Unwilling to admit that he knew exactly who shot him. However, he wasn't willing to say that Christopher Keller didn't shoot him. He wasn't willing to go that far. And he wasn't willing to go far enough to say that he pointed a gun at him.
Hold on, help the jury. Your last thing was he pointed a gun at him. Thank you.
Joseph Williams said he did not pull out his weapon until shots had already been fired. Remember that? That's what he said. His weapon had not been pulled out until after someone started shooting at him. Also, not really willing to admit that his mom could have been shot, his sister could have been shot, his niece and nephew could have been shot, that everyone was being put in danger. This is the middle of the day. Unwilling to admit that. But will tell you that he did not pull out his firearm until later, and that Christopher Keller might have been the one that shot him, but he just doesn't know him. Shyla Guidry, mother of both of them, also protecting Christopher Keller. All family, right? And what she says is she thinks her son might have, but she doesn't really know because she was ducked down and just in fear. And she didn't really see anything and it was all a blur and everything just happened and everyone was shooting and she just doesn't know, right? But then we get to Kayla Garlington, who doesn't know the three of those people, has no real connection to them, just kind of knows them from around, but is friends with the defendant and does know him. What was her testimony? Christopher Keller took out his firearm and started shooting 4 to 5 times before Joseph Williams ever took out his handgun. She says Christopher Keller started shooting because Shyla Guidry spit on him. That was her testimony. And her testimony actually matches the physical evidence that we have, right? Remember when this all starts, everyone's over here, right? At the front of the car, and we have the defendant, Christopher Keller, right here on the driver's side. What happens? Something makes Joseph Williams run this way, over here towards this car, and down, right? And Kayla Garlington also runs. Now, what does the physical evidence show? The physical evidence shows that this window was shot, probably as Joseph was running this way. The car was shot, and this car was shot right here. And where was Joseph Williams shot? In his butt, as he was running away. This man was no longer in danger. Nothing was happening to him. In fact, someone was retreating, was running away from him, and he was shooting at him. That's not self-defense. You don't get to shoot at someone who's running away from you. You don't get to shoot at someone who's in fear for their life and retreating. And at no point did this man ever try to retreat. Kayla Garlington, his friend, testified that she offered him a ride and he didn't want it at that time. She offered to make the fight stop to drive him away and go. And he didn't take it.
I didn't hear any testimony reference that she tried to drag him away and go.
Right. Overruled. The jury will recall the evidence, ladies and gentlemen. Y'all have been listening and paying attention intently, and that's your job, is to recall the evidence and apply the evidence to the law as the court has given to you. Go ahead.
You'll also see on the video that at some point, Christopher Keller does walk to the back of the car, and Joseph Williams walks this way. And you'll see Christopher Keller run at him. And then Joseph Williams runs away towards the west. That's not someone retreating. That's someone starting something. And you being spit on is not justification for you to pull out your weapon and start shooting. You being spit on is not justification for you taking out your firearm and just spraying bullets at an apartment complex in the middle of the afternoon. What was the testimony from the officers? These two casings were from the victim. These two. And where were they found? They were found over here by the white car when it shows up. Over here. If Christopher Keller had already started shooting over here and the victim's gunshots are over here, who do you think started it? His gun couldn't have jammed if he did manage to shoot. And no one's arguing that Joseph Williams shot twice. We have the evidence that he did. How many times did the defendant shoot? Well, if there's 19 and only 2 of them belong to the defendant, 17. That's not someone trying to defend themselves. That's someone trying to kill someone. Joseph Williams should be very happy that that man is a terrible shot. He's so very lucky to have only gotten shot in his butt and for it to come out his thigh. Doesn't want to admit to the fact that he had to have surgery. Doesn't want to admit to any of it. Because he's lucky that nothing happened to him, and now he wants to protect this man. Or maybe they're afraid of him. Maybe they think that something might happen for their testimony. I don't know. What I can tell you is that they weren't honest with any of you. That they didn't even want to admit that this is the video of the shooting. I would ask them small questions and they would agree with me until they realized where those questions were going, and then they wanted to backtrack it, right? That video shows you everything. It doesn't show you the gunshots, but it shows you what happened. It shows you a man that was not retreating. It doesn't show Joseph Williams pull a gun, but it does show Joseph Williams is running away when he got shot. Would a reasonable person continue to shoot someone who is running away from them? Is there danger at that point? I would argue no. Just because these people don't want to hold this man accountable doesn't mean that we can't. Charlotte Guidry referred to Avery Trace as the OK Corral. Granted, she didn't understand what Mr. Burbank was saying, but she still said it. And she's right, it is the OK Corral. People just do shootings over there all the time. And we need to hold them accountable for that. We need to stop this violence. It is not okay for you to get in a verbal argument with someone and to just start shooting. It is not okay. And that's not what we want for our community. And the last thing I want to point out to you is the fact that Who was there when the police showed up? It was the victim, right? He had been shot. He was there. EMS was called. When he was standing in there for surgery, he said he wanted to prosecute, that he wanted to follow through with it. That C had shot him, being Christopher Keller. He's willing to admit that much when he was facing surgery, when he thought he was in danger. I can't tell you what made him change his mind on prosecution. I don't understand why he wouldn't want to hold that man accountable. I don't understand why they wouldn't want to hold someone accountable who put their nieces and nephews and grandchildren at risk. I mean, they literally shot through an apartment. But you know who wasn't there when the police arrived? Christopher Keller. He didn't stay to be like, he pointed a gun at me, man, and I didn't know what to do, so I started shooting. That's not what happened, right? He didn't claim that it was self-defense. He just ran. And why do people run from the police? Because they know they did something wrong. And it's up to the 12 of you to hold that man accountable when the people he hurt won't. Thank you. So.
Ladies and gentlemen of the jury, this time I am passing the jury charge to the bailiff. Please step down from the jury box, follow the bailiff into the deliberation room. We will await your verdict. Alternates only, by law, only 12 jurors are allowed in the jury deliberation room. We're going to ask you if you'd be so kind, hold vigil outside and wait. There have been times when alternates had to replace jurors during the course of the deliberation. Thank you for your patience. Thank you for your time. And please wait outside close by. We'll keep you updated. Thank you very much. We're in recess.
Yes.
Please.